You're welcome.
Really, really appreciate it.
You're welcome.
You have no idea.
Is the audio rolling?
Mm-hmm. Yep. Yeah, audio is already rolling. Well, yeah. Do you want to start with Susan's story?
Sure.
Is that a good lead-in for
Yeah.
you?
Do you want me? Should I identify myself or?
We'll do that later.
Okay.
Yeah.
Okay. The state of Ohio versus Susan Gwynn was actually the first case that I reviewed as a new Supreme Court justice. And it involved a woman who was charged with various counts of burglary. She was entering senior citizens' homes for a long time and taking items of property from the senior citizens that live there. And these items were not traditionally items that a thief that is looking for resale value on the street. They were a lot of trinkets and family pictures, some of which had a lot of sentimental value for the victims. But she wasn't trying to resell this property. She was actually hoarding this property in her home. And I was a mental health court judge for 9 years on the Common Pleas Court. So 25% of my docket was made up of people who suffered from mental illness, schizophrenia, schizoaffective disorder, and other conditions. And this was a red flag, these facts, for me, that this may be someone suffering from mental illness. But she was in another county, and she was caught, and she was charged by the prosecutor in that county with a lot of felony burglary charges that all stood on their own for each time she entered one of the senior citizens' homes. Well, she received a lawyer. They negotiated a plea bargain. She pled to nearly half of those counts, and that was the benefit she thought she was getting. And she was informed at her plea hearing. I read the transcript with great interest about how the judge informed her of every single possibility she would face if she entered this plea bargain. And this included probation. Several times the judge said, now if I give you prison, this will happen. You could be on supervision for any of the items we did not find. You could pay restitution and so forth. But he also went over all the prison possibilities. She could be served concurrently. Prison sentences could be imposed concurrently alongside each other, or they could be stacked on top of each other. The prosecution was silent as to what they intended to advocate for at the upcoming sentencing hearing. So Ms. Gwynn entered this plea. She was referred for a pre-sentence investigation, and she showed up at her sentencing 30 days later. For the first time, she heard the state indicate what they were going to be advocating for, and that was 42 years in prison. The defense lawyer stood up and he advocated for probation, or what we call community-controlled sanctions here in Ohio. And the judge did not take or stay within any of those boundaries. He imposed a 65-year prison sentence on Susan Gwynn without parole eligibility. So Ms. Gwynn found out that of the day of her sentencing, as a matter of fact, that she wasn't going home on probation, that she was going to die in prison. She was 57 years old or near that, and she would have to reach the age of 120 to fulfill her debt to society. So that's how much discretion trial court judges have in this state. That is a classic example of what I would call sentencing by ambush, because a lot of people, when they hear, if they're outside the justice system, they believe that a plea negotiation is like a contract. And that's what we tell the public, that this is a contract between the government and the accused in order to resolve the case. And in contracts, typically people are giving up a detriment, both sides, in exchange for a benefit. But unfortunately in plea bargaining, the benefit is sometimes withheld from the parties with outrageous results. And you find out that in your negotiations, you're not really negotiating for a benefit as the accused. You're negotiating for what's behind door number 3, what you'll find out at your sentencing hearing, which could be a benefit or it could be a very long prison sentence that you could not have anticipated in your wildest dreams. And that is taking place daily basis here in Ohio, and I'm sure throughout the nation and in other state courts.
It's so heartbreaking.
It is.
I mean, the idea of longer than I've been alive to be told when you thought
Right.
when you thought you had probation.
Right. In Ohio, we don't have a lot of sentencing data. Our judges are told under our laws that we are to treat similarly situated defendants with similar sentences, regardless of the color of their skin or their socioeconomic place in society. But we don't have data that keeps track of our own sentencing and the sentencing of our colleagues on the bench. For 14 years, I did the best I could. No one ever gave me a sentencing memorandum and said, "Judges, this is how you've sentenced in the past." In the federal system, they have that type of data that helps control judicial discretion, prevents against implicit bias or explicit bias by the judge in sentencing. So that's a big flaw presently in our criminal justice system. And as a result, you have a complete loss of proportionality in sentencing in Ohio. You can literally go into one courtroom with the same lawyers, the same set of facts, and you can conduct a sentencing hearing, and the outcome will be probation or community control, what we call it here in Ohio. Or you could have that same sentencing 15 feet across the hall in front of another judge, same lawyers, and wind up with 20, 30, or more years in prison. So we've lost proportionality here in Ohio without data. And as a result, you have unexplainably lenient sentences with violent offenses and sex offenders. And you have a case like Susan Gwynn, a property crime, which keeps her in prison. And there's no guardrail like a parole board that could say, well, look, this person is no longer a threat to society. They've rehabilitated themselves as we want them to do. She doesn't have that guardrail. Murderers and rapists will make it to the parole board in Ohio before Susan Gwynn is released. And she won't be released because she has to reach the age of 120 to finish her sentence.
And she's still in prison.
She's still in prison.
And there's no hope.
Her only hope is that she could receive judicial release by the judge, but she has to serve half of her sentence until that she's even eligible for that. Or she could possibly receive a reduction of her sentence from the governor. But those avenues are very, very rarely granted.
Hold this one second. Since we've settled, I'm just going to readjust this slightly. Okay.
Okay.
It baffles me. I'm sorry, Brent, but I can't help but talk.
Oh, no.
I'm not going to wait on you.
Okay.
I think what a lot of people come to is like, why? Why does this? Why would they do that? Is it to kind of appease some people? You know, you have a lot of people that got their things stolen, and specifically in this case where it's sentimental and whatnot. Why such an extreme use of force? Because they can?
Well, we have different theories of why we punish people, and our policymakers haven't tended to focus on one. What we tell judges in the state of Ohio, when they have discretion, they are to sentence people to punish them for the offense that they committed, to protect the community from future offenses by that particular offender, to set them on a course towards rehabilitation so they hopefully can re-enter society and not re-offend. And we want to use the least amount of our limited public resources to do that. That's what we are told to do. But in Ohio, when you have the legislature has given prosecutors a vast amount of authority in the forms of new crimes. Our criminal code in the state of Ohio has expanded from, in the 1980s, all the crimes in Ohio was contained in one book, and now it's 5 or 6 books. I haven't checked lately. And what that represents is leverage, because the party that wields the most power in the criminal justice system, it's often not the judges, it's the prosecutors, because they have the ability to charge. And in Ohio, you can take any given set of facts, and if you can charge numerous crimes that are all supported on their own by the facts that took place in that particular crime, then depending what's left on the table, either after trial, but more likely, in 97% of the cases, it's the plea bargain, that's going to leave on the table a vast amount of authority. And so when the judge conducts that sentencing, when you have those huge parameters of discretion, that judge's sentence can be affected by a lot of variables. They could be moved by the victims in the case. In Susan Gwynn's case, it involved a lot of elderly victims, and their family members were very upset. I mean, think about how you would feel if someone came in and took your grandfather's Purple Heart, right? So, I don't fault the judge in that case for the sentence he gave. A lot of people, when they hear me talk about that case, they say, "Are you criticizing the judge?" And I'm not. I'm criticizing the system, because no one, myself included, should ever be given by the law discretionary barriers that allow me to give a single person that I am sentencing either probation or 150 years. That's just too wide of an area of discretion, especially if there's no checks or balance on it. The appellate court, as long as I say the magic words in sentencing and refer to the statutes in question, my sentence will be totally insulated from any type of review here in Ohio. And there's no independent parole board like there used to be. Prior to 1996 in Ohio, they had a parole board that would individualize examination of defendants and say, this person's dangerous, this person no longer is, and would make those discretionary calls on the back end. That's a guardrail on judicial discretion, and those guardrails simply don't exist right now.
When you talk about data and that there isn't any, I'm approaching this, and I wanted to say this. I'm reading a book by a senator, old senator. It's called Language and Thought in Action, from Sam Kawa. I can't remember his last name, but learned a lot. But he says, when you're learning a language in specific fields, I'll make some missteps. So this is not my field. This is my field.
Mm-hmm.
I know how to build things. I know how to do stuff.
Right.
So if I misstep, sorry.
Yeah.
In business I understand. And a business mentor of mine told me one time, if you don't track anything, if you're not tracking it, then it doesn't exist.
Right.
So it's very baffling to me that something so life or death we don't track.
Right.
But we track money,
Right.
ins and outs. And so I think, that's probably something that we can just both agree on, like, why? Why is this not a thing? Why
Yeah,
are we not
that's a great
keeping track?
question.
Yeah.
Because we haven't collectively, as all stakeholders in the system, asked the question that you are asking. Why? Why are we doing what we're doing? Now, if you start there and you say why do we punish people? Okay, number one, if you want law and order, and we have a set of laws that we all agree on, once they are passed, whether you agree on them or not, the great American experiment is based on if if you have a law, you must follow it. If you don't like the law, you change it. So we pass these laws. There has to be, in order to maintain law and order in society, a consequence for breaking those laws. I think no matter what end of the political spectrum you're on, we could all agree on that, right? And I think most reasonable people agree with the notion of proportionality. That's been around since the time of Aristotle. Treat likes alike, regardless of irrelevant factors like the person's race or their socioeconomic place in society. So how do you get there? And how do you achieve these policy goals of public safety? And you're exactly right. You would have to collect data and have the metrics in order to see if those policy goals are being fulfilled. And if you don't do that, you can't find that. It doesn't make any sense for violent crimes to be given these lenient sentences when theoretically our duty is to protect the community from future violent crimes, or nonviolent crimes for people to spend decades and decades in prison. Not only from the human cost, which is terrible, and it destroys families, but there's also a tremendous monetary cost to the taxpayer. Millions and millions, billions in Ohio. We have nearly 50,000 individuals incarcerated in the state of Ohio, and we lead the nation in that mass incarceration. And that's scary from a lot of different perspectives, because there's a tremendous cost, and there's no guardrails. And you would think that our citizens would want our policymakers to be measuring those metrics in order to most efficiently achieve those policy goals. Let's just make an analogy with with another profession, the medical profession. If you had an ailment, would you rather be treated by a doctor who retired 20 years ago, or would you rather be treated by a doctor who is 10 years into the practice and up on every new study about what we've learned in the last 10 years, which is amazingly significant, in order to make a decision about your health? I mean, you don't even have to think about it, right? Why wouldn't we do the same in the criminal justice system, which, when you give the government the power to charge you with a felony and take away what we as Americans value the most, and that's our freedom, that's one of the important things a judge can make. So why would we not want those metrics? This is the way the society is going. I mean, a great movie to look at for analogy is Moneyball, right? I mean, who were the decision makers in Moneyball, which is based on a true story, that used to make the decisions about who baseball teams hired in order to compete against the other competitive teams that may have large income levels. And so the decision makers in baseball were the scouts. And they relied on their experience and institutional knowledge. And they would go out and watch players, and as they watched more players, they developed instincts about who would be a good prospect. Sometimes they were right, sometimes they were really wrong. They were using the tools they had, but a lot of times they were going on their gut. And that's what judges are presently doing in our society. It's not an indictment of them. If they don't have the tools that they need to make proper decisions and use that discretion as wisely as they could, then that's our fault, without providing them the data that they need. In 14 years on the trial court bench, I never received a sentencing memorandum before sentencing that said, "Judge, I want to remind you of your duty under the law to treat similarly situated defendants with similar sentences. Look at my memorandum. I have attached 100 cases, some of which are yours, some of which are your colleagues, and this is how they've sentenced in the past. I would love to have had that information, but we don't have it right now. And as a result, you're going to get disparity in sentencing, not only between judges whose courtrooms might be right next door to each other, but you're going to have disparity with those individual judges. Because trial court judges make sentencing decisions a mile a minute. Every single day, they plea people and they sentence people. When people say, before you were on the Supreme Court, what did you do? And I would say I was a trial court judge for 14 years. But the way the system has evolved, if you looked at all the time spent on my criminal docket, even though I tried my fair share of trials, most of my time spent on the criminal docket, as every judge, is overseeing plea hearings and sentencing hearings. I have a plea colloquy, I accept the plea, and I refer it to him for a pre-sentence investigation. Then I have information in front of me, and then I conduct a sentencing hearing. And that's how the system moves. There's a famous quote by a U.S. Supreme Court justice who once said, plea bargaining isn't just a big part of the criminal justice system in America. It is the criminal justice system. And no truer words have ever been spoken.
Yeah. Yeah, it's I think it touches on this thing, and I wanted to get into this. Why don't people care? I know why I care, and I probably wouldn't have.
Mm-hmm.
You know, so it's a bit of a blessing that I
Yeah.
have this history, that I can do this. But for me, my observations, and this is only in the masses, everyone's like this. Everybody's just looking at their phone. Everybody's very distracted. And I wonder if is that part of it? That we just don't really care that much? Or, and certainly I don't expect you to have these answers. These are kind of whatever. But just in your idea, is it a pacification problem, or a distraction problem, or just it's not happening to me problem?
Yeah, that's part of it. I mean, I think a lot of people will develop a tolerance for disparity and unfairness that takes place in the criminal justice system until it happens to them or one of their family members. And then they want something done. And that's a big problem. The way our system is designed, there are very good things that, what I would say, the cornerstone of the American justice system, which makes us different from authoritarian countries, like other countries around the world, is that in America you are supposed to be presumed innocent, right? If you're going to give the government the power to accuse citizens of crimes, and if you convict them of those crimes, you take away what we value the most as Americans, then the cornerstone of due process is that the person is presumed innocent, and the onus is on the government to prove the truth of that matter beyond a reasonable doubt in front of a jury of your peers. That's a very important protection. And then you have an adversarial system where you have a constitutional right to go to trial, and the government must put on evidence, and you're able to challenge that evidence in open court, so that neutral jury and hopefully the neutral judge will allow the process to play out, and juries can make the correct conclusion, and they are told by law, if you are not convinced beyond a reasonable doubt of the truth of the charge, then you must acquit the defendant. Okay, and we understand that notion in America that when you have a system like that, some people who are actually guilty are going to escape accountability, and that's an injustice. But we view, or we should view, what I view as the worst form of injustice, and that is to have an innocent person incarcerated in prison and take away from that person what we value the most, and that's their freedom. And there's all other policy issues to talk about. When you talk about innocent people, you know that if there is a true perpetrator, they are still out there. And there's been instances where they have eventually, after many years, exonerated people, found out who the true perpetrator was, and they had gone on to commit other crimes, victimize people, and harm people, and this could have been prevented. So, what are the you said why does this happen? Well, our criminal justice system has evolved to process a tremendous volume of cases.
Well, and it's not necessarily how does it happen, but in your opinion, why do you feel like people just don't seem to care? Like we don't have a whole lot of push. I don't feel like, I mean, we have Just Mercy and some other like wrongful conviction things coming out, and like that's good, but as far as like the masses, most people are just kind of eh.
Well, I mean, I think that's true of American life with a lot of important issues. I think a great thing to happen would to go back to the importance of teaching civics in elementary school, to understand why every American should understand what the role of the judiciary is, what the role of prosecutors are, what the role of defense lawyers are. I used to have students come in and I would give a presentation on the justice system, and one of the questions from the students, and sometimes this came from high school students, they said, I just don't understand how a defense attorney could represent someone that they know is guilty. And I would say to them, well, that reflects a misunderstanding, respectfully, of the justice system, because they are just as important as prosecutors, defense lawyers, to the process of getting justice. Because what do? When someone's accused by the government of committing a crime, they are there not to question whether they're guilty. They are there to make sure that the process proceeds as designed and to protect the rights that are enshrined in our Constitution, rights that people, men and women, our brave men and women in our services, fought and some died for to protect. So defense attorneys are very important to bringing about justice in our justice system. And it comes back down to what we hit upon before. I think people get engaged in their daily lives, and not a lot of people during their lifetime, thankfully, find themselves in felony court. If you're going to find yourself in the court system in America, you're most likely going to find yourself in a municipal court for a traffic ticket, a speeding ticket, huge volume there, and they have to plead out a lot of cases, and you'll see shenanigans take place in muni court because of the volume and how they have to process cases. Let's say you're charged with speeding, and you know that if you admit to that speeding charge, you're going to get 2 points on your license, and your insurance is going to go up as a result of that. Well, if in a lot of jurisdictions, if you have the right lawyer, they can go in and they can have a negotiation with the prosecutor, and they can turn that speeding ticket into something like broken taillight or loud muffler, something that is not factually true, but it doesn't carry with that 2 points. You still have to pay the court cost. The court still gets the revenue. And this happens all the time, every single day in American courts. Okay, it happens in felony court as well, but with with very much more serious implications. One of the first reform efforts I engaged in as a trial court judge was to eliminate the practice of judges allowing what I call factually baseless pleas from resolving cases. And where I saw this take place was usually in sexual assault cases. Someone would receive charges coming out of the grand jury indicting them with either rape or some other form of serious sexual assault, and there would be some type of backroom discussion with the judge, the prosecutor, and the defense attorney. Usually the accused is not there, and if there's a victim in the case, usually they're not there at all either. And all of a sudden, you would see the defendant pleading to a charge that has nothing to do with sexual assault. And it would circumvent sexual offender registration laws. And, you know, I've seen rapes pled out to interference with custody charges, downloading pornography, illegal child pornography, being transformed into a felonious assault to resolve the case. And I brought a lot of data I collected on this, and I gave it to the press, and they did a front page story of it. And we tried a national, we engaged in a statewide effort to ban these types of pleas. We wanted to amend the rules that said if a prosecutor presents a charge that in no way resembles what you originally charged the person with, in order to accept that plea, the judge would have to, on the record, request that the prosecutor outline facts that, if true, supported what that person was admitting to resolve the case. That didn't pass in the state of Ohio, believe it or not, with no explanation why, and it resulted in a headline you can still Google in the Columbus Dispatch that says, Ohio rejects truth in sentencing rule, which was one of the factors that led me to leave the trial court and seek a seat on the Ohio Supreme Court, because I wanted to work on policy, judicial policies that would improve public confidence in the court, because public confidence is the lifeblood of our justice system. They have to have a belief that our outcomes in our criminal justice system are based on truth and based on fact. And if they lose that faith, that is the bedrock of our democracy, our judicial system. And if we lose that, we're in big trouble.
I agree.
Yeah.
I completely agree.
Yeah.
I actually have, because of how I grew up, I have a deep distrust. I can't help it. It's
Sure.
ingrained in me to have a deep distrust of any authority. Any authority at all. I'm just kind of like, I don't trust you. I've worked through it.
Yeah.
I'm all right now.
Sure.
Thanks for asking. But
Sure.
And it's that kind of stuff in the article that you had sent us after Brent and I were on the phone with you. You mentioned sometimes it takes celebrity to get someone exonerated. Right. And that just spoke directly into that. Public opinion matters so much in this. That someone that has almost nothing to do. Like, celebrity is a nonsense word.
Right.
It's just like, people like them for some reason.
Right.
I mean, of course, they're like good at wheeling and dealing and rubbing elbows with people. That is a talent that I admire, but they have no point in being in the system.
Right.
You do.
Right.
You studied for who knows how long.
Right.
Continually. And so, yeah, that kind of public opinion, it erodes. I see it in my life and how I'm raising my kids. I'm trying to be like, sometimes this stuff happens. They know what I'm doing.
Mm-hmm.
And so I have to communicate to them like the nuance of all of this.
Yeah.
It's hard to communicate to a 10-year-old, but we'll get there. But the deeply in those, because this specifically, I have 2 adopted boys, black boys, and the stat that keeps haunting me is that 51% of exonerations are black.
Mm-hmm.
They make up 13% of the population.
Right.
That erodes so much.
Sure.
You wonder why traditionally there's an issue in law enforcement and black people. They don't, that, there's that mistrust there.
Right.
And we need to work to build it back up to where we can say, hey, I believe that you have my best interest, and obviously the best interest in, if I did something wrong. But that public opinion is part of what I'm trying to do here.
Sure.
Is to, yes, we push against, but we should also be for, this is a pro-reform movie here,
Right.
Not a slamming kind of.
Yeah, people ask me, a lot of times when I go to reform-minded meetings, I'll run into, especially from the defense bar, who have been in the trenches all their career, and a lot of them become, for lack of a better word, jaded, and they believe that the system is just broken beyond repair. And I don't believe that. I believe that we always have the opportunity to improve the system, and I've seen it happen. We did not have open discovery here for many years in the state. And what that means, when I started as a prosecutor in my career, I would go to pretrials, and I was not required to show the contents of my file to my adversary, the defense lawyer, the representative of the accused. I would go to pretrials and I would read from police reports and witness statements the information that was contained therein. And the defense attorney would take copious notes, and they would have to trust that I was telling them everything they needed in order to properly represent their clients. And I didn't question that system when I was taught that as a young prosecutor. I thought that's the way it's always been done. Makes sense. We represent the state, not the victim, but we have an obligation to protect victims. So if we wanted to keep addresses away from the defense lawyer, at least until trial, we should be able to do that in order to protect victims from retaliation and intimidation. That was the policy that we thought justified that. This was in effect when I became a trial court judge in 2005, and it was not uncommon in every case that went to trial for people to be complaining about getting information either the night before trial or worse, during the midst of trial. And people felt like they were being ambushed. And they had a lack of confidence in the prosecution that took place and the judges. And the defense bar and some journalists in the state finally rose up and exposed the problem and the flaw to the public. And the public agreed, and they said the legislature and the judicial system responded, and we demanded open discovery. And in 2010, that became the law, that prosecutors must turn over everything they have in their files in order to allow the defense to properly assess the case and represent their client to the best of their ability. And the system became more fair when that took place. I saw that. So I have hope that our system, by promoting transparency, can become a better system. You're right. Right now, when people are wrongfully convicted in the area of post-conviction, it's probably the most non-transparent, the most in need of reform area of our criminal justice system. That's the back end, because when people are wrongfully convicted, it is very, very difficult for the system to agree to have a second look at the case. And that's why is that? It's because we expect the judicial system to resolve disputes and bring finality and closure to victims and come up with the proper resolution in terms of whatever the sentence is. We just haven't accepted that in a system run by human beings, there is going to be mistakes. And when you and Brent and I talked yesterday, I made the analogy of let's talk about systems run by humans and how much confidence you would have in a system if you knew the error rate that existed. So the first DNA exoneration that ever took place in the United States took place in 1989. And according to the stats, roughly 400 exonerations in our country's history occurred prior to that 1989 date. Now, since that time, we're hovering in at 4,000 exonerations nationwide. Now, think of another system that requires public confidence, the airline industry, for instance. People, in order to fly from Austin to Cleveland, have to have confidence that if you get on that plane, you are going to get there safely, right? I would equate wrongful convictions to the airline accidents that take place. And when something terrible happens in the airline industry, the industry knows that they have to respond quickly and they have to find out why did it happen and how do we prevent it from ever happening again. And that's why airline traffic is so safe. We need to apply the same types of guardrails in the criminal justice system in order to make sure that we do everything to prevent wrongful conviction on the front end. But when it happens, as we know it will, that how do we remedy it on the back end? And I've said, oftentimes when someone is innocent and in prison, and they claim to have new evidence that, if true, would completely undermine the theory of guilt that was used to convict them, that was told to the jury, that came back with that guilty verdict. If they have new evidence, they deserve to be put back at square one with a new trial, presumed innocent, and then the ball's back in the government's court. Okay? But to get there right now, it's almost impossible. You have to struggle for years. It's not enough to just have a good lawyer. It's not enough to just have good evidence. Sometimes you need a celebrity from Hollywood to come in and shine exposure into the case. You need journalists to repeatedly say, what this person is claiming. They deserve a hearing in open court. Right now in this state, if you have new evidence, the judge is not required to afford you a hearing in open court. They can look at the motion and they can look at the state's motion opposing it. It might have to do with someone who has completely recanted their testimony that they delivered at trial. And the government might say, well, that's not trustworthy. Well, that may be true or may not be true, but the only way you can examine that is by having a hearing. And right now, people who claim innocence are not afforded that ability, that transparency to be granted a hearing where they can present the evidence, and the evidence will either rise or fall and give the original conviction integrity. Most of the time, however, when people claim that they have new evidence, the evidence rises and it demonstrates that the theory of guilt that was used to convict them is completely undermined and they deserve to be put back at square one.
Can you, just real quick, sort of describe that theory of guilt for the audience?
Sure.
There could be a concept that people don't really understand about the system.
Sure. I think a lot of people need to be reminded that in our criminal justice system, when the government brings charges, the prosecutors who bring those charges are not witnesses to the event. They couldn't be. It would be a conflict of interest for them to be so. So what prosecutors do is they examine evidence collected by our police agencies, and they develop a theory of guilt. That is what they present to the jury in order to convince them beyond a reasonable doubt of the truth of the charge that they are bringing. But every case is simply that. It may be a very strong theory. There may be videotape that convinces the jury very quickly of the truth of the charge. But it may be a very circumstantial case. And even though the circumstances suggest guilt, you may find out later new information that, had the jury known that information, that would have questioned whether they made the right decision as to whether the truth was proven at that original trial. But it's simply a theory of guilt. I believe that every prosecutor should be under some type of obligation by rule that at all times they should have a good faith belief in the guilt of the person that they're prosecuting, right? I mean, and I think most prosecutors across the nation would agree with me that they've examined the case, they've done their due diligence, they've interviewed the witnesses, and they've come to an honest belief that the person is actually guilty of what they've been charged with, okay? But there is no obligation, at least in this state right now, that let me start this over.
Yeah.
I'm going to give an anecdote about this.
Yeah, while you're thinking, do you need any water? You need anything?
Do you have a water?
Yes.
Yeah, I can, but I can deliver this. So when I was a young prosecutor, I was charged with prosecuting a burglary case, and the sole evidence against the defendant was an eyewitness testimony by the victim. A victim had been minding a store in a commercial area. A defendant, African American defendant, had walked in, pointed a gun, took the money out of the car register, and left. Well, they didn't have any clues to go on who this was, but 30 days after the incident took place, the victim saw someone walking down the street, and she felt 100% certain that it was the same person who did it. So she called the police. He was arrested. He was charged. She denied from day one that he was involved in the robbery, and I was assigned to prosecute that case. So I knew I had a burden at trial to prove the truth of that beyond a reasonable doubt. As any young prosecutor, I wanted to win the case. But after a number of meetings with defense counsel at pretrials, I heard from his counsel that his client swears up and down that he didn't do it. Interestingly, he said, I may be able to squeeze him into a misdemeanor plea if you can get that, but he wants to go to trial. So I remember having a beer at the end of the week with one of my colleagues, and I was expressing doubts after all I had learned about whether we had the right person. And I remember a young prosecutor, and I remember my friend saying to me, that's not your job. Your job is to follow your marching orders that you received out of the grand jury. You're to stand in front of that jury and you argue that it is him, 100%. And you let the jury decide what the truth is. That's the way the system works, and that's the way it should work. And I walked away from that, and I thought, I don't know if I agree with that. So then I went to a supervisor that I respected, because a lot of young prosecutors don't have the discretion to just simply drop a case. But I outlined everything that concerned me about the case, the fact that the defendant's clothes were searched and he had no clothes that matched the outfit given by the victim on the day of the occurrence. And after listening to my concern, my supervisor grabbed the file, took his Sharpie and wrote, "Dismiss." And I walked up into the courtroom and I said to the judge on the record, "We do not feel that we can ethically proceed with this case and argue that the defendant is guilty beyond a reasonable doubt." And I remember the judge ordering the defendant being released, and I remember him looking over at me and he said, "Thank you." He goes, "I swear I did not do this." And I never forgot that incident. And back in those days, we as prosecutors actually had a firm belief that eyewitness testimony was the most reliable testimony that existed out there. During voir dire, it was not uncommon to say, "Hey, Mrs. Smith, if you were robbed in broad daylight and someone stuck a gun in your face and demanded your purse and ran away, don't you agree that that incident would be so startling to you that that person's features would be emblazoned upon your memory to such a degree that you would be able to recognize that person 1 week later, 5 years later?" And yes, I would. "Well, Mrs. Smith, you're acceptable to the state. We pass for cause. Next juror." This is the stuff that took place back then. And we believed it. We had an honest belief that that was the most reliable. Well, what do we know now? It's the least reliable form of evidence, which is very scary. Later, many years later in trial, I was trying a murder case, and the defendant claimed that he was being antagonized by the victim in the case. Now, one of the witnesses was a person across the street who claimed to have witnessed the shooting, and she described a shooting very different than what the defendant said happened. She described a shooting that happened execution style. Well, fortunately for the defendant, there was a videotape on the store of what went down. And it more corroborated the defendant's story that he was being grabbed by the victim back before he turned around and very quickly shot him. There was no sit-down execution style shooting. And we brought in, this had to be disclosed to the other side, of course, because it was Brady material. But we put the witness on the stand because there was still a shooting and there was an allegation. It was a homicide. So we put the witness on the stand, and she was given her statement by the prosecution, and she watched with absolute astonishment the videotape of what she described in her statement on the day in question. And she was a very credible witness. She was not lying. She just believed, based on her memory, that this is what happened. And she said she was flabbergasted, and I must have been mistaken. I'm sorry. But that's what we have to deal with now that the advancements in science about human memory has to be taken into account. And the unreliability of eyewitness testimony is something we have to contend with as a system.
Well, even in society,
Yeah.
Because in my father's case.
Oh, thank you.
In my father's case, even now.
Right.
As I'm talking to so many people about this, they're like, "Well, how do we know he's still, even still,
Oh, yeah?
And it's because we as the masses still believe we're not keen on this information. It hasn't made its way down as much. I'm familiar with it. I talked to Miko Wilford. Do you know her?
I'm not sure.
She's a psychologist, and that's where I learned that from. It's like
Yeah.
it's the least reliable source. Like, oh, well, cool.
Yeah.
Uh,
I'm aware of a seminar that took place in Ohio, which was open to judges and prosecutors, and some fire experts were delivering new education for the professionals there about the advancements in fire investigation. And in one of the frames, they actually had a frame that said, hey folks, it's not like, and this was their quote, the good old days, where you could just have the fire investigator say, it started there. That's what they described as the good old days. Now you have to know the science. And we know for sure that many people who were convicted of arson and homicide involving arson were convicted with completely junk science. And those cases need to be revisited immediately.
yes, this reminds me of when we talked a while ago. You had
Angela
mentioned-
Garcia?
Yes.
Yeah.
Oh my gosh, that one's
I'm just gonna make my notes too.
quite quite like that one's stuck with me.
And there's a podcast out that I'll send you on
Yeah.
that focus on that.
Oh, amazing.
Yeah.
Yeah.
And that's where that was my first encounter with the dark plea. This is where I started formulating my thoughts on what the dark plea.
This is great.
Yes.
This is where I'm wanting to go next.
Okay.
If you'd like to discuss, because up until this point, just to kind of give you where we're at in the film, we know what plea bargaining is.
Yeah.
We don't know what dark pleas are necessarily. And I think the only case that we have up until this point is my father's case in the story. So, I mean, I'll cut up your interview throughout the whole thing.
Yeah.
Just to kind of give you a framework.
I mean,
to
your
sit within.
your father's case is more evidence of the coerciveness on the front end of the, but it's indicative of the same thing. Your father's case is indicative of.
When we refer to the case, can we call it Troy's case?
Yeah.
Your father's case?
Yeah, sure. Troy's case is indicative of wrongful convictions that took place before open discovery and the problems that existed there. And the problems about prosecutors telling defense lawyers factual evidence that does not exist. The penalties that exist for the crimes that Troy was charged with are immense. They give the government great amounts of leverage in terms of getting people to consider, even if you're innocent, consider the possibility of resolving the case by entering a plea bargain rather than exercising your constitutional right to trial. We say in our case law that people cannot be punished by exercising their constitutional rights. But in a system that is dominated by plea bargaining, that's just simply not reality. The fact that if you exercise your constitutional rights, you face a trial penalty. Here in Ohio, we call it the trial tax. And that may be discretionary by the court, or it may be mandatory. You know, some of the people are charged with these horrendous crimes and they have mandatory life sentences, okay? So you're dealing with a lot of leverage, but there's leverage that takes place during the investigation, like being told lies about what your outcome will be if you admit to what they are alleging and what you're denying took place. If you're being lied to, how do you trust with any level of confidence the truthfulness of that admission? Okay, so we need to recognize as a culture that the coercive level, we need to recognize in the profession the coercive level of leverage that's being exercised in some cases is so strong that an innocent person would be foolish not to consider a plea bargain to resolve the case.
And this is what you would classify as a dark plea.
Yes, well, there's coerciveness on the front end, but the dark plea is a form of plea that I coined as a phrase because I believed it needed to be given its own name. The dark plea is a legal fiction, and if your viewers don't know what a legal fiction is, it's a lawyer made-up term for lie. Because plea bargains should be, if they're going to be used at all, used to resolve pending charges, accusations against the accused, in which they're both negotiating for some degree of benefit. The government's seeking some level of resolution without having to use all their resources to prove the case. The defendant's looking for something too. They're looking for a degree of leniency in the outcome. That's on the front end of the system. Plea bargains, in my opinion, should not be used to resolve cases that have already been resolved. So what happens in post-conviction when someone claims they're innocent, and if they're fortunate to be granted a hearing where they can present the new evidence that, if true, undermines the theory of guilt that was used to convict them, oftentimes what happens before they reach that point, the government will approach them, and this is why I call it dark pleas, because it happens off the record. The negotiations generally don't ever, or at least the specifics, don't make it into the record. And they will offer the accused the keys to the jailhouse door, the prison door, and their freedom in exchange to pleading and admitting to what they've already convicted them of. So to identify what a dark plea is, you go to the moment when it's offered, and you ask, is the person under the cloak of the presumption of innocence? And if they're not, then that's a dark plea. The dark plea I would describe as the legal equivalent of, on the front end of the system, having someone point a gun at someone's head and demanding that they sign that confession. Because what they are saying is, you can take the chance and present your evidence with the complete uncertainty you have right now about what the outcome is. Or you can take the immediate walk out of jail free. You'll still have the conviction on the books, but you'll have your freedom. You make the choice. And a lot of the data, some academics have done studies on the dark plea, and people are starting to talk about the ethics of using these dark pleas. I've argued that they should be outlawed, and that prosecutors should be prohibited from offering these types of pleas because they are absolutely way too unconscionably coercive. And because oftentimes, and the data suggests that people say, why would a prosecutor do that? Here, like, this is what's not asked. This is what I'm hoping your documentary will ask this question, because even journalists out there that cover these plea bargains in the news don't ask this question. Why would a prosecutor, who after seeing what the innocent claim contains in terms of new evidence, after they've seen and evaluated that evidence, and let's say give them the benefit of the doubt that they still have a good faith belief in the guilt of the defendant, why would they ever offer a plea bargain offering that person's freedom before a hearing took place and learning whether that they are going to have to face a new trial? And I've racked my brain over this, and I've come to the only conclusion that is supported by logic, and the answer is this: they would not offer that plea unless they knew that if they went to a hearing, they were going to lose and they were going to face a new trial. So they use the ultimate trump card, at that point, and they say, you can take the risk and go to that hearing and see what the judge has to say, or you can walk out of jail today, but with the conviction still intact. So you can imagine the private discussions that must take place between the innocent advocate and the innocent claimant after that dark plea is offered. So the innocent advocate walks back and says, look, we're ready to go to the hearing. And the prosecutor has approached me, and they have an offer. You can get out of jail today. You can walk out. You can plea. Maybe you might be offered what we call an Alford plea. But you can maintain your innocence, but your conviction will remain intact, and you'll get out of prison. Or you can take the risk of going to a hearing and seeing what the outcome is. And the response might be, I don't understand. We have new evidence that proves what I've been claiming all along. I'm innocent. Don't you think we'll win? And the advocate might say, yeah, I think we'll win, but I can't guarantee you that. Well, what happens if we lose? Well, then we'll have to go to the Court of Appeals, and that's going to take a couple years. Well, what happens at the Court of Appeals? Do you think we'll win there? Yeah, I think we'll win there. I think you'll get granted a new trial or at least a hearing, but I can't guarantee you of that. Well, what happens if we lose there? Well, then you're going to have to spend the rest of your life in prison. That's how these exchanges must take place. And so that's the level of coerciveness, and you can see why innocent people take those kind of pleas. Often with grave results. I've spoken with innocence advocates who have had clients accept these dark pleas, and they have to live with the guilt throughout the entire rest of their lives of being forced to admit to something that they know is not true, and often with tragic results. And that's a tragedy, and I don't think it should be prohibited in the American justice system.
Well said. Well, two things I think would be good to cover is what does the audience need to know about the process? Like, how can they protect themselves in the bent, I'm not going to call it a broken system, but the bent system that we have? How can they best serve, what's some good advice that you have for them around that? And then also, just kind of touching on what you already said, feel free to get a drink.
Okay, thanks.
The mindset of the person that's coming out, new evidence has emerged. They're coming out and saying, oh man, I might be able to get out, but then they come with this plea deal, and you're already, well, it didn't work out for me before. I have no faith that their faith in the system is already failing.
Yeah.
And so they're taking advantage of someone that's already beaten down mentally around the system or the faith in the system.
Yeah, a lot of innocent people who have now been exonerated, fortunately. They were offered pleas in their original case, and they turned them down because they trusted the system. They trusted that if they exercised their constitutional right, that the system would get it right. So you can see with someone who's been wrongfully convicted, they come out of that experience with a grave mistrust of the system. And I could understand why, when they're being offered the dark plea, why they would accept it. And I would never fault anybody from doing that. I can't imagine myself under that level of coercion. I think in order to move the ball forward in the system, I think we have to have a culture change in our adversarial system. People who represent prisoners who claim that they are innocent, they are viewed oftentimes by prosecutors in our system as simply defense lawyers who are looking for a second bite at the apple for someone in a system that's supposed to deliver finality. And that's unfortunate, because when you think about the system, innocence advocates, as they should be identified, they aren't defending anything. On the back end of the system, it's like a reverse image of the mirror image of the front end of the system. They become the prosecutors. What they are saying is, look, we have evidence that proves that the theory of guilt that was used to convict me has been completely undermined, and we want the opportunity to demonstrate that. And the prosecutors on the back end of the system, they become almost like reverse defense lawyers. They have a question to ask. Knowing what we now know, does this conviction have integrity? And they have to make a choice. Do we just simply allow this person to be exonerated? And some prosecutors will do that. There's conviction integrity units throughout the country, which is great, a great change in the culture. But some prosecutors continue to maintain that belief that the jury always gets it right, and they fight these opportunities that are being sought to present this evidence in open court. And they fight it tooth and nail. And sometimes on the system, judges will let motions for a new trial that are fully briefed, they may let those motions languish for years, 5 years, 6 years, without a ruling. And the innocence claimants are reluctant to push the judge for a ruling because they don't want an adverse ruling coming back their way. So they wait. You don't want to antagonize the person that you are seeking a favorable ruling from. So these things will languish. And people who have thankfully been exonerated, we've been able to look at the dockets and the court-caused delay in the system that exists in post-conviction. And it comes at a tremendous cost, because if someone is fortunate to get compensated for all the years they spent in prison, you can look at the delay, and that delay has cost the taxpayer millions of dollars as a result of reaching the right conclusion, the truthful conclusion that could have been arrived at a lot earlier. The answer lies in transparency. The answer lies in providing guardrails on the post-conviction system. And by guardrails, that means rules that force judges to conduct hearings when people represent that they have new evidence that supports that the theory of guilt has been completely undermined, and allow that evidence to be presented in open court. Because that kind of transparency, that usually results in innocent people being released. And they need to be given the equivalent on the back end, speedy trial. We have speedy trial rights on the front end of the system. Why not have those kind of guardrails on the back end of the system, rather than let people's claims languish for years?
Yeah, you mentioned open court. Actually, let's take a little, just breathe a little bit,
Okay.
and then let's do this. You can introduce yourself now that we've been talking for however long.
Okay.
And then I would love, yeah, go ahead and do that, and then we'll do the
Okay.
next.
I'm Justice Michael Donnelly. I'm an Associate Justice on the Supreme Court of Ohio.
Wonderful. And then we'll do just one more time, just for.
I'm Michael Donnelly. I'm an Associate Justice on the Supreme Court of Ohio.
Beautiful. Cool. How would your daughter describe you?
Well, my daughter and I are both musicians, so I, in my spare time, play in a rock band, and so does she. She's a bass player. So she probably would describe me as cool. Nowadays, thankfully. Back in her teens, not so much.
Oh, that's so good. I'm also a musician. I got to play with my kid. I'm teaching my kids how to play drums. There's nothing better, and you know this.
Yeah.
That connection that you feel with another musician is so fun.
Oh,
It's
yeah.
so addicting.
Yeah.
And to get to do that with your kid is just like, I didn't know this could be.
Oh, yeah.
It just happened for me, so I'm interested to hear how.
Yeah, I have a video a couple years back. My band played and we invited my daughter to play bass on a Rolling Stones song, and she and I played that together, and that's one of my most cherished memories. That was just great. Yeah,
It's so good.
definitely.
Man, yeah, God. Well, and there's a certain heart a musician has,
Yeah.
a realness, and I wonder if that's kind of where I want to go next is this open court thing. Why you're kind of in your own lane out here, from what I understand, and I want to understand what was it that made you feel so strongly that needed to happen, even against such pressure on the other.
I think it was right when I was elected judge I was elected as a trial court judge in 2004. And I remember approaching the job in the weeks that I was wrapping up my legal practice and knew that in a week or so I was going to be making very profound decisions on people's lives, sending people to prison. And it really made me nervous. And my father was a judge, and we had a discussion, and he said, look, Mike, people elected you, and you're a fair person, and you go out there, and when you put that black robe on, you remember that you represent something that is bigger than yourself. You treat everyone with respect, and you try to make the best decision that you can in order to be fair to both sides and promote confidence in the courts. And that was the greatest advice I had. So a couple of years into my first term, I would engage in plea bargaining the same way I did as a young prosecutor. I didn't question it. The prosecutor and the defense lawyer would come to a tentative agreement, and they would come to see me, usually in my chambers, to discuss what they were proposing, and they were seeking my approval of the plea agreement. So that's what takes place in a non-transparent system. A lot of these discussions take place back in the judge's chamber, off the record. And I began to question that process. And I would say the biggest epiphany of my career came one day when I thought about the process from the neutral perspective, and I arrived at the conclusion that these discussions really should not be taking place in the back room, because in the back room no one should say anything, the prosecutor, the defense lawyer, or the judge, that they wouldn't repeat verbatim in open court. So one day I made a change. I asked my bailiff, I said, we could still have these same discussions, but we will do this in open court, and there'll be a court reporter there, and they will take down every word that is said, including mine. And why is that important? Because when people go on the record, no one wants to lie on the record or say something that can be refuted to make them look foolish. No one wants to appear threatening or coercive. And everyone's held accountable for the role that they play. And once I started doing that, I never looked back. I did this till the end of the time I was on the trial court before I joined the Supreme Court. And I've come to the conclusion that every court should do this, because transparency is what promotes public confidence and ensures that the process is running the way it's designed.
Mm-hmm. Yeah, we were on the plane. I sat next to someone, and I am who I am. I can't help it.
Yeah.
And I talked to her, and then after we were in the car, and I was like, "What did you learn from the people you sat next to?" And nobody learned anything, but I learned she's about to divorce her husband. She's having a hard time. She works.
Just so some of us aren't as nosy as you.
She wanted to tell me the thing because I was open and honest and transparent about who I am.
Right.
And it's this infectious thing that if you're just who you are and saying things openly and honestly and transparently, and other people want to be transparent too.
Yeah.
And you have to lead that way.
Yeah.
And I think that's just, I'm so thankful that
Yeah.
you do that. You had mentioned on the phone some awful things are said. Are you comfortable sharing anything, or is there anything that, like, does anything come to mind that you would be willing to share?
Sure. Judges may, in Ohio, there's no objective criteria that guides judges on whether to accept a plea agreement or not. So judges, there's 400 some common pleas judges in Ohio, and they exercise their discretion in a variety of different ways. So it could happen where the parties come back and they say they've come to an agreed sentence. The government and the defendant agreed to probation or agreed to 5 years, and the judge might arbitrarily say, "No, I don't like that proposal. I'm not taking it." That will often not make it into the record that the judge said that or said why, the reasons why, and so it can never be reviewed. I had one trial court judge told me one time that that the room prosecutor that was assigned to the judge was getting constantly chastised by their superiors as not being zealous enough for the state as a prosecutor. And what they would do is have a backroom discussion, and the prosecutor would say, "Hey, judge, I'm going to be pounding on the table and asking for 10, 15 years out there, but I really don't think this guy deserves more than 3. And I thought about that, and I thought, well, who did that serve? Was there a victim in the case that didn't know that a charade was taking place in front of them and what had been represented? And on the other the other side of the coin, a defense lawyer once told me that in the back room, if they were representing someone who had a terrible criminal history, that they would represent to the judge that, "I know my guy's got to go a long time." And that flabbergasted me. Like, that's not your role to be arguing or even conceding that. You're supposed to be out there mitigating that. My guy, you can always say something in mitigation, right? Like, my client took responsibility for what they did, and so the roles can easily, when non-transparency takes place in the back room, the roles that people are supposed to play in our adversarial system can easily disintegrate, and people can forget the role that they're supposed to play. When you're on the record, that doesn't tend to take place. There's a case here one of the cases I reviewed for the Ohio Supreme Court is called State v. Dunlap. And I wrote a dissent because I couldn't get 4 of my colleagues to bring this case in. And what the defendant in that particular case represented was that he was charged with a high-level drug marijuana case. And if what he is stating is true, his attorney had told him that he had a discussion with the judge, and that if he entered the plea, that he was going to get probation. If the judge gave him any time at all, it would not exceed 60 days. So he went into court, he took the plea, and in Ohio, during the plea colloquy, the defendant is typically asked, has anybody made any representations about what sentencing consequences you would obtain if you enter this plea? And oftentimes, even if that representation is made, the defense attorney will represent to their client beforehand, you answer no. So I call it one of the biggest lies that takes place every single day in courtrooms throughout Ohio, throughout the country, I'm sure. And what happened to this particular defendant is, after he entered that plea and made that representation, they went immediately to sentencing, and the judge gave him an 8-year sentence. So that person, if he's representing the truth, had been told that he would receive probation or 60 days in jail, and then he went off for 8 years in prison. He made a motion to withdraw the plea. He requested a hearing. He said he had evidence to support his contentions. That was denied. And he went off to serve his 8 years.
I don't know what to do with that information.
Yeah, I mean,
That's a
it's on record. Yeah, I'll send you the transcript. I'll send you the opinion. But I couldn't get 4 of my colleagues to bring that in. They didn't think that was important enough. I guess. I can't read their mind, but I couldn't get 4 votes.
Golly. Is it frustrating for you?
Yes, it's frustrating, but I know there's enough people out there that know that these problems exist, and it's very rewarding for me to do things like this, like to go on camera and answer questions about the reality of the system in order to make it move in the right direction. You know, I'm reminded of Martin Luther King's famous quote, you know, the arc of justice is long, but the arc, what is it?
Oh, I'm thinking of an injustice anywhere is injustice anywhere is oof.
I think the
We're
quote
really
is,
good at
yeah, I
remembering
think
Martin Luther quotes.
Martin Luther King stated, the moral arc of the universe is long, but it bends towards justice. So he understood that change is slow. And it happens incrementally. And I think if America is going to continue to prosper, we have to improve our justice system by making it the most transparent and the most efficient, the most accessible to all our citizens. And so that's what motivates me to keep moving and teaching young lawyers. What really gives me hope is the new lawyers that I meet in law schools like this. I come and lecture, and they're very interested in social justice. They see the horrifying effects of wrongful conviction, and they want to do something about it, and they're motivated. And so if I can provide them without these observations that I've come to, I didn't get them overnight. I didn't, like I said, when I began as a judge, I didn't question a lot of this. Like you're doing in this documentary, I tell young lawyers that the most important question they should be asking as they enter the profession is why? Why do we do things? And don't be satisfied with the response that you will inevitably get it's because this is the way we've always done it. Don't be satisfied with that, because there's a better way of doing things, a more transparent way, a more effective way. And they're excited by this. They're excited by data and the importance of bringing data into the system for policymakers to make laws that make our sentencing more proportional and fair for all people, regardless of the color of their skin, regardless of their socioeconomic place in society, and to foster that public confidence that is the lifeblood of the system.
Yeah, that's great. Oh, what a bonus. I didn't know you were going to mention that. Okay, how are we on time?
So we're at 3:30. We're going about 90 minutes almost.
Okay, cool. We're flying through all that I intended. I would like to... Do you know much about Joseph Allen's case?
In Lorraine?
Mm-hmm.
Yeah. No, Nancy Smith? Yeah.
What a fascinating,
Yeah.
odd case.
Yeah.
Would you be willing to talk about it?
Yeah.
So maybe kind of in story form, that whole thing, and then any opinions that you might have on what led to. I mean, golly, very nuanced and very, very strange.
Yeah. I mean, you could probably get Nancy Smith.
Yeah.
Yeah, I could put her in touch with you. She would, if you want to interview her,
Yes.
and she could tell you about how she was forced into that plea.
Yep.
Yeah, I can make that happen.
Okay.
Yeah.
And Joseph Allen is still in prison, correct?
No, I think he's out. He's out now.
Exonerated.
Yeah, he was
But
exonerated.
like 13 years
Yeah.
after, right?
Right.
Which that's the, yeah, what an odd, yeah.
Yeah.
I'll let you, I don't know that these guys know it.
Yeah. So I was a young prosecutor when that took place, and it was a neighboring county, and the allegations were horrific at the time. I mean, and it was at a time when similar allegations were being made across the country. McMartin trial out. Are you familiar with that? That in California, the McMartin, I believe I'm getting that name correctly. They owned a daycare center, and they were accused of doing horrific acts. And it was after that allegation took place, similar allegations began to crop up across the country, and one of them occurred in Lorain County. And the allegation against Nancy Smith, she was a bus driver in Lorain, and a mother came forward and said her kids had been taken by Nancy Smith instead of straight to school to someone's house where awful sexual crimes occurred, and then after they took place, they were brought to school and delivered on time to the school. And Nancy Smith, of course, denied these allegations, and I believe the police investigated some of and a lot of the police who initially investigated didn't want anything to do with it because they couldn't find any corroboration. But the prosecutor who handled the case brought in other investigators, and they put together this case, and a lot of evidence was not turned over, like videotape of one of the mothers grabbing a child's arm and pointing it during the lineup at the person that they knew was the suspect, who was Joseph Allen. And there was a Dateline documentary that you might still be able to find on the internet covering the case called The Shame of Lorain. It was on Dateline. And I remember seeing the footage of when Nancy Smith was convicted at trial, and she's standing next to Joseph Allen, and she's in front of the judge, and she's looking at the judge, and she's saying, "I've never seen this man in my life. I've never seen him in my life. I can't." She couldn't believe that this was happening. But she was sentenced, and off she went, and she did 13 years in prison. And if not for a set of circumstances where the original trial court judge left the bench, and a new judge came in, and the new judge was Judge Burge in Lorain County, and the new judge held a hearing, brought them all back, and he reviewed the transcript of the original trial, and he did something very highly unusual, but very courageous in my mind. He said the charges should have been dismissed after the state's presentation of the evidence, and he let them both out. This got appealed to the Intermediate Appellate Court. It was upheld, and then it went up to the Ohio Supreme Court. I was not on the court at the time, but they reinstated the conviction. They said the judge was not able to do that, what he did. So it went back, but instead of sending Nancy Smith back, they said they offered her a plea to time served and allowed her to stay out. They didn't do so for Joseph Allen. And I think the reasoning was he had a prior criminal conviction or something like that. But they did say he would be eligible for parole after 10 more years. So they sent that's what happened to the both of them. And then the new prosecutor out there took a second look at the case, and within the last couple of years, they had a hearing where she was completely exonerated. But it took a long time. And yeah, if you want to see firsthand the tragedy of wrongful conviction, interview the people that were involved and see how, you know, horrific allegations that you don't believe any human being could engage in can propel the system into not slowing down and having an objective look and just wanting to get the most highest level of vengeful justice. You know, that's sometimes what moves the system in ways where the system fails to operate properly and look at the substance and question the merit of the evidence and the truthfulness of it. Yeah, but that's a case, you know, would be well worth interviewing, because she's still the traumatic effects of what happened to her and Joseph Allen. I'm sure I've never met Joseph Allen, but I met Nancy Smith, and it's awful what happened to them.
Yes. Yeah. It's an alarm because it seemed very malevolent.
Yeah.
On the side of the accusing.
Right.
Which was very surprising. I think in my father's case, I think it was. Well, we don't know. It wasn't malevolent, but it was just mistaken, or who knows what was going on. But for something like that, that's so overtly pointed.
Yeah.
It's quite alarming to me.
Yeah, I mean, and we talked about this in our prep talks. I mean, you got I started my career as a prosecutor, so I have a high degree of respect for ethical prosecutors who understand their role to seek truth, to seek justice, to seek proportionality in the consequences. And I think a lot of prosecutors unfortunately get defensive when you talk about wrongful conviction, you know, but there's a lot of prosecutors out there who understand, or who are beginning to understand, that the system doesn't get the results right, and there's a need for conviction integrity. So I'm hopeful that we're moving in that right direction. But people have to understand that prosecutors, in dealing with the crimes that they prosecute, they come in to contact on a daily basis with a lot of dark human behavior. I mean, I saw it as a trial court judge, but prosecutors have to do this day in, day out, sometimes dealing with horrific crimes that are perpetrated against innocent children. And the danger in being exposed to such darkness like that is you develop a us versus them mentality, you know, and that's something that has to be guarded against. My hat's off to prosecutors who dedicate their lives to seeking justice for victims of horrible, depraved acts that are committed by people. But in the justice system, it always has to be maintained with those principles that it's governed by, that everyone, the accused, is always presumed innocent. And that is what forces, or should force, an examination of the merits of the substance behind the allegations, not just the allegations itself. Yeah, you know, you have to look when evidence is the good thing about the adversarial system is when evidence is presented in open court and it has the opportunity to be effectively challenged, then the truthfulness usually, in my experience, rises or fails to rise to that standard that protects us all, which is the presumption of innocence.
Brent, do you have anything? Paul?
Yeah, I have two questions.
Okay.
Specifically, this one's about, I think it's called open discovery, in
Yeah.
which the prosecutor has to disclose, the state has to disclose to the defendant all the evidence they have against them.
Yeah.
And you were saying that in the beginning of your career, you just sort of, it was just the way that it happened before it changed in Ohio, that
Right.
that open discovery. So I wonder, first off, if you could just kind of describe what open discovery is, and then why does it seem like that's a good idea? It just doesn't seem like that's a good idea to me, because it keeps the defendant from having all the information they need to make a good decision about their life. So if somebody comes to me with a plea, but I don't have all the information about the evidence that's against me, how can I make a really good decision about whether to take that plea or not? That's kind of where I'm coming from with this. So it's
Yeah.
two-parter. Just kind of describe open discovery,
Right.
and then why would anybody think that that was kind of a good idea?
Okay, so
Maybe it's not a good idea.
no, I mean, we've always had discovery. There's always been this concept in the criminal justice system that, there has to be an exchange of information between when the government makes an accusation. They're forced to, under the rules, provide the details. A bill of particulars is what we call it in Ohio. So that we've always had this notion of discovery. It's just not until, I believe, 2010 did we obtain open discovery, open file discovery. And the discovery which took place prior to that was an informal type of arrangement, which was not on the record, where you met with the defense counsel and you represented as the prosecutor what you had in terms of the evidence that supported the charges. And this was the evidence that you were, as the prosecutor, going to present at trial in front of a jury if that was necessary in order to prove the truth of the charge beyond a reasonable doubt. And I did not question this as a prosecutor. If anybody ever questioned the policy behind why don't you let defense counsel see and read for themselves the police report or the witness statement, we would simply say that we control the information, and that's the utility behind that is we have a duty to protect victims and from not being intimidated or retaliated against. And defense lawyers in the state kept getting frustrated because the discovery that was provided at these pretrials was not often complete. And sometimes they would receive information right before trial, after they had prepared their defense, that completely altered the way they had prepared their defense in light of what they were given. And this wasn't fair from their perspective, and it wasn't fair from any perspective. So they said, we want to see firsthand what you're representing at these pretrials. We want to read for ourselves what the police report says. We want to read the witness statements because we want to be prepared at trial. If the witness gets on the stand and says something materially different, we have a right to cross-examine them about what they said originally. And we're not getting this right now. And we feel like we're being ambushed. And they made enough of a public outcry that it forced people to say, let's look at the arguments against open discovery. Let's look at the arguments in favor of it. And once they did that, the arguments against it were it revealed that the arguments against it just didn't hold water. And even now that we have open discovery, I don't think you'd find a prosecutor who would ever who would ever argue to return to the old way, because they realize that it's made the system more fair. When a when a defense counsel in open discovery has the material that either supports the charges or supports a lesser charge, they can take that to their client and they can have confidential discussions, and they can reason with their client on what and advise them as to what the proper outcome should be in this case. I can negotiate a plea bargain for you, and I can hopefully obtain consequences that are acceptable to you, rather than taking the risk of going to trial and having more severe consequences occur. And they can navigate that. They can also make decisions about whether their client's rights were violated, right? Did the police follow the rules in terms of finding the evidence that they found in this case? Did they have probable cause for the warrant they obtained? Those are kind of questions that defense attorneys need to know in advance so they can properly advise their client and represent their client. Should a motion to suppress be filed in this case? Should this evidence was this evidence obtained in a legal manner, or should we file to have it excluded? These are all the questions that are going through the defense counsel's mind as they prepare for that trial date. And that's why the discovery process is so important. The system itself runs on good information. It's always run on good information. Resolutions are like, here are the charges, what's the information that supports those charges, and then people can react properly. And now, in this day and age, as we emerge into a data-driven society, it's even more support for the argument that more data is needed. Good decisions are made when people, the decision makers, are provided with the best information possible.
Yeah, great. Yeah, that really clears up my question.
Yeah, I think one of the other things, I think we're just kind of like tying all the loose ends now.
Okay.
Sorry that it might be a little bit more disjointed.
No problem.
Less of a conversation. Kind of, you touched on it a little bit, but what would the audience need to know as far as just keep on pushing? Or do you want to never take a plea? You know, that's obviously a very large window there, but...
You know, there's some reform advocates out there that say we should get rid of plea bargaining. And it's an interesting thought experiment, but I think the train's left the station. We have the system that we have now, and it's pretty much guided by plea bargaining. So if that's going to be the system, we need to examine what's taking place, what's acceptable, and set up guidelines and rules for what's not acceptable. Are people receiving benefits that they're negotiating for? Is there too much leverage being exercised on the front end of the system where the plea is way too coercive? Are the consequences that are being obtained through these plea bargains conscionable? Are they achieving the policy objectives that we want to in a fair and just criminal justice system? Are we achieving public safety? Are we reducing recidivism? Are we rehabilitating people? Are we treating people that should be treated differently? For instance, if you have a valid reason to treat someone different, let's say they're mentally ill. You know, my mental health court docket for 9 years 25% of the felonies were people who suffered from schizophrenia and schizoaffective disorder. And I'm very proud of the fact that we were able to keep a lot of the mentally ill out of the prison system, where they're abused, where they often come out worse, and at the same time keep the public safe. Because if people were properly medicated and took their medications, they tended not to get involved in activities that brought them back into the criminal justice system. So there's more, that's another thing about hope in the system. When I started my career, the idea of drug treatment courts, mental health courts, they were scoffed at as being coddling criminal behavior and being soft on crime. And I don't think you get those arguments from anyone anymore, because you see the effectiveness of it and the cost benefits of it. The criminal justice system comes at a tremendous cost to taxpayers. And that's why you see a lot of people on the right end of the conservative end of the political spectrum agreeing that a lot of these reforms are worthwhile, because they see the fiscal irresponsibility that is taking place, that a system of mass incarceration can't be maintained. It's unsustainable if you want a productive society. It's just not an objective that is being achieved when you incarcerate people that don't need to be incarcerated.
Yeah, very, very, very good points. Something that came up for me in that, unless you have anything.
I have something.
Okay,
just
Paul.
kind of tying back into some
Sure.
previous trains of thought here.
Okay.
Kind of going back to, we're talking about the exposure of those that are in the judicial system to the dark human behavior.
Yeah.
And when we look at the lack of data that you've discussed very fully here, it leads me to kind of just piece together these concepts of, the high stress, the exposure to that human element that is so currently key to those decisions that at times have very large guides. And so I'm curious to hear kind of from you more, kind of tying those concepts together, this contradiction of the lack of data, but then it's supposed to be finding, I guess, this sense of justice. And so if we don't have the understanding of the parameters, how are we trying to whittle that down when it's seemingly so high stakes and high emotions, and more importantly, the stories that you've told come back to very egocentric, very personal gain driven. I think you said the prosecutor who was talking about, or the defense who was talking about, the 15 years, even though he knew it was only 3 that they're fighting for. I guess the prosecutor. I guess to me, it just seems like those elements of those who are participating, they're so motivated to find their own personal gain instead of those of their client, or instead of those of the person that they're representing or serving, whether that's the public or.
Mm-hmm. Yeah.
I'm having a hard time kind of bringing it to one question.
Yeah, I understand what you're getting at. I was on the Ohio when I was on the trial court, the highly acclaimed podcast Serial spent a year examining my court, and they would travel from courtroom to courtroom, and Sarah Koenig, who produces Serial Season 3, in my opinion, did a great job of exposing a lot of the non-transparency, a lot of the coerciveness that permeates the criminal justice system, as just a system that brings in cases and produces resolutions and then moves on without regard to the big questions like why? Why are we doing this? And in fact, when she ended that podcast, as she looked back on everything she had reported on and observed, that's what she ended on. This question is like, why? Why are we doing this? And I don't think that question is being effectively asked by all stakeholders in the system. You know, why do some prosecutors feel that if you're successful in obtaining a conviction, why do you ask for the maximum sentence? Why do you ask for the maximum sentence? Just because you can? Why do you object to judicial release if there's evidence that supports that the person's no longer a danger to society and they've been adequately punished? Why aren't we asking these questions? Because we all want public safety in our society, right? You know, one of my favorite legal movies is A Few Good Men. And there's a great exchange that doesn't get a lot of play because it's got such a great courtroom scene. But they're defending, in that particular movie, they're defending two servicemen who are accused of murder. And they're, throughout the movie, being offered plea bargains, very sweet plea bargains, but they refuse to accept that plea bargain. Why? Because they feel they would be admitting to something that was not true about the allegations. And so they go to trial. During the trial, one of the co-defense attorneys asks, or it expresses frustration about having to represent these people that he feels actually took advantage of someone. And the character played by Demi Moore asks Lieutenant Weinberg, why do you hate these guys? And he says, because they bullied on someone that was less advantaged of them. And in response, he says, why do you like these guys so much? And she says, because they stand on a wall and they say, no one's going to hurt you tonight, not on my watch. And it's a very important piece of dialogue about our country and about our system. These rights that we all cherish, they come at a price. They need to be protected. The country needs to be protected, and you have to have it. They don't assert themselves. They have to be protected and constantly asserted. And if we're going to have a system that achieves the goals of public safety, rehabilitation, law and order in society, we have to have a transparent justice system that works and is as transparent as possible and data-driven as possible to get to that point where we can say, wait, it's working here, but it's not working here. We need to make these policy changes to do so. And that's the best answer I could come up with, because you hear people pound on this is my right. My Fifth Amendment rights were violated. My Fourth Amendment rights were violated. Well, that might be true, but unless you have a system where you can advocate and demonstrate that, and you have judges who follow the law, then those rights don't mean anything unless you have an independent judiciary that asserts those rights. Is that getting at where you?
It's incredible, yeah.
Yeah.
That really ties it well.
Yeah, something that came up for me with that was, you look at what it does, not what it says. It does.
Right.
Right. And
yeah, the what it says it does are just words on a paper, right?
Yep.
And we need a system where everybody stays in their lane, and the judges are. You need an independent judiciary, which scares me right now, because it's become our system here in Ohio to our U.S. Supreme Court is at a state where public confidence is at its lowest in our nation's history. And why? Because politicization of the judiciary has taken place, and the public, a large swath of the public, have come to believe that we're just another political branch that just gets moved by whatever the majority wants at a given time, and that's not what America was built on. We have laws, and those laws must be followed, and that's what we do. When I take an oath of office, I swear my allegiance not to any political party, but they'll follow the laws of this state and the U.S. Constitution, and we have to return to that.
That's great. Yeah. Yeah. Well, and you are someone that does. And I really appreciate that.
Thank you.
Yeah.
I try.
Well, yeah. I mean, I was telling Brent, it's like we worked fairly hard to get here. It wasn't. I've done a lot harder work, like remodeling someone's house, than how hard it was to like have a conversation with you. And in a way, I'm like, I wish people knew, like, if you just worked a little bit harder than you are, you can affect a lot more change.
Right.
But I think this is like what I keep on coming back to is like, I know that people have a lot of power.
Yeah.
Public opinion means a lot.
Yeah.
But the public doesn't have belief in themselves.
Right.
And that's what I keep on coming up against is like, I wonder if this is the issue here. That's like, we need to believe in ourselves and the system that we have.
And we need to educate people more about the system. I mean, I agree with, and a lot of people are saying this on both ends of the political spectrum. We need to return to civic education in this country from day one. And people have to understand how the government runs and how it's supposed to run, so they can they can raise their voice and maintain a healthy democracy. That's what power is. Public officials have. I've always understood that it's a privilege to serve in this capacity, and I'm only there because for a limited time the public has put me in a particular position to exercise decision making and to use that time, the limited time that we have, to try to make the system better for the next generation. And everybody has an opportunity to do that, and no one can do it alone. You have to work together with every stakeholder in the system and try to advance the system towards its ideals. It's an unfair world, but that doesn't mean that we don't try to make it as fair as possible.
Yeah, I love it. I think last thing, unless you guys have stuff, I'd love to get your opinion on some AI stuff.
Mm-hmm.
It's something. I mean, we use AI. I think everybody uses AI at this point at some point in their life. But that's one of the things that we're trying to do well in our production is integrate new tech.
Yeah.
So I'd be curious to hear thoughts, opinions, and maybe future projections of what might come.
I just spoke about a year ago. I spoke to the new lawyers of this state who were just sworn in after passing the bar, and I told them, we really need you right now because you're on the cusp of a change that's about to take place in our society that may be the biggest challenge humanity has faced to date. And we need good lawyers to do that because of its technology that I understand it can provide tremendous advancements in the justice system and our ability to make consistent, fair, proportional, data-driven decisions. But there's also huge dangers. There's the power of misinformation to make decision makers make very profound decisions on people's lives. So the world I predict that we are experiencing right now here in 2024 will not be the world, will not look like where we're going to be in 5 years, 10 years from now. I mean, that's what we're sitting on right now. It's a massive advancement that we have to get grips on. And there's in every profession we can advance human society for good, but there's also huge dangers, and that is not lost on me. That's how I met Fred Pinto, who wrote an article on the Atlantic, and he pointed out the disparity that exists in an imperfect criminal justice system that's run by human decision making. But AI has the opportunity to evaluate huge amounts of information that we never had before, and give us the ability to treat similarly situated people with similar outcomes and more effective outcomes, reaching the policy goals that we all want in the criminal justice system. So I'm optimistic, but I'm also very concerned about the dangers that exist as well.
Very much. I mean, deepfake alone.
Yeah, deepfake alone, and we've already had instances documented in the legal system of briefs being filed, written by AI with sites that don't exist, of case law that doesn't exist, that the court said in this particular case, and when people looked into it, sometimes it was correct, but if it couldn't find something to support what you wanted it to advocate, it cited cases in support of that didn't. It made up its own cases. So that's a danger. I mean, that's yeah.
That's alarming.
Yeah, and deepfakes. I mean,
Yeah.
Deepfakes. You've seen how they've advanced from when they were first introduced, and they're getting better, and that's something absolutely terrifying that we're going to have to. Because if you can create a videotape that puts you at the scene of a crime, and you can't tell the difference between whether it's real or whether it's not, it's dangerous. Yeah.
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 That's why we need good lawyers.
Right.
To your point.
Right.
And yeah, and experts in AI, and there's a whole thing that comes along with it.
Oh, yeah.
I think you're so right. It is.
Yeah.
Buckle up.
Monumental.
Yeah.
Yeah.
Yeah. Overwhelming to think about.
Right.
Well, and yeah, I think that the data processing is really cool.
Yeah.
A very, very cool thing to lower that burden. And maybe a little bit more predictable sentencing for those
Right.
through, right? Like, oh, so-and-so got this.
Yeah.
AI typically does it this way.
Right.
It's more predictable than human behavior,
Yeah.
at least right now.
Yeah. I think we're going to get to a point where we're going to see the advantages of that, and I just hope that it's used responsibly. So.
Me too.
Yeah. Buckle up. Well, I don't want to get political in this, but we're in the midst of an election that, from time to time you hear this is the most important election of our lifetime. I don't see how you can't say that this is the most monumental crossroads that we've been at in my lifetime. I mean, there's some important decisions that have to be made, and democracy's at stake, and the rule of law is at stake, and that's something that we need to contend with, and the voters have to make some decisions about which direction this country's going to go.
Yeah. Yeah. And maybe get off of this thing so you can pay attention to what's actually happening.
Right.
Yeah, golly.
Yeah, the constant. My daughter, was over visiting the other day. She lives with her friends in Lakewood, but she's got Tic Tac on her phone, and they scroll and scroll, and what's going on? Like what? That has a profound effect on what's going on in the news, what people believe. That's probably one of the more concerning things that I've seen in my career. Is when I began my career, there was a huge media presence in the courthouse. There was a beat reporter, and that kind of transparency was a good thing, because if a beat reporter came into your courtroom, everyone wanted to look good. Everyone wanted to behave as you should in your particular role, and that transparency, that local journalism has diminished, and people seem to be interested only in the most salacious cases, fact-driven cases, and rather than the investigative journalism that needs to take place, like what's going on systemically in terms of how people are being treated, and what the outcomes are achieving policy-wise, which we need to have. We've always had the press there as the watchdog of our democracy, and if they're not there, that's when misbehavior takes place, and that is a deterrent against that. So hopefully it will be replaced by some form of media that that acts and replaces that watchdog role.
Mm-hmm. Yeah. Even taking it, well, whatever. We don't have to get into how I would do it or
Yeah.
how I would build that system, but yeah. You guys good? Okay.
Thank you.
Thank you.
Yeah,
thank
thank you.
so much.
Yeah, and if you want me to make any contacts with Nancy Smith or anything like
Okay.
that, I'd be happy to put her in touch with you.
Amazing.
Yeah.
Ugh.
So you guys are in Cleveland for another couple days?
Yes, sir.
Definitely Rock and Roll Hall of Fame,
Okay.
and definitely if you can, make it over to the Cleveland Museum of Art.
Oh.
Yeah,
Yeah.
it's amazing.
Yeah. I'm so excited.
Yeah.
Yeah, and you're not playing a show anytime soon that we can see?
No,
Okay.
I'm heading down to Cincinnati to campaign, so
Okay. Oh, man.
tomorrow, yeah.
Is that, I wanted to ask you, I mean, off record or whatever. That's exhausting, isn't it?
Oh yeah, yeah. Yeah, I used to, when I campaigned in Cuyahoga County, traveling from Cleveland Heights to a suburb, 25 miles away used to seem tough, and now traveling all over Ohio, but is exhausting. But you meet a lot of people. Ohio is a very diverse state, and what I found very satisfying about talking about the justice system is it doesn't matter if you're talking to rural, very staunch conservative, law and order type people, or progressives in the inner city. There's a lot of common ground in what they want from the justice system. Fairness, accessibility. Judges are the referees of society. We're there, as John Roberts says, to call the balls and strikes. And if people think they're getting a fair shake, then that's a good thing on both sides. And so when I go in front of a crowd and I get that kind of response, it reinvigorates me for the next trip.
Yeah.
So,
Good.
yeah. Well, so thanks so much.
Yeah.
Yeah. I'm glad that this space worked out. It looked out. Yeah.
It's
This is
fantastic.
great. Yeah.
I love it.
Yeah.
It looks incredible.
So,
Awesome.
all right.
Appreciate you so much.
Yeah. Appreciate you guys.
so
Great
much.
meeting you.
Great to meet you
Yeah.
as well.
Yeah. Thank you. So, you need help breaking stuff down or
Oh, no.
Okay.
You're okay. Thank you. It's
Okay.
very, very Midwestern of you.
All right. Yes, we are. That's great. Midway.
Can you get some photographs of him before
Oh,
we
yeah.
get the lights gone?
Yeah,
Yeah. You want to photograph him?
Yeah,
Yeah,
please.
we're gonna-
If you don't
Just
mind.
sitting down?
Yeah, just on the same spot.
Okay.
Let me.
Sorry about that. Here, let me just fly this out. Okay.
Okay.
That works.
Turn the flag at all?
Huh?
You gonna turn the flag at all?